Welcome to our first lecture on the Fair Labor Standards Act, which is usually called the FLSA. So that's what I'll probably be calling it most of the time. We're going to cover many topics in this statute. This statute has lots of different components. It's a little bit unusual in that it is a law that kind of covers many separate areas. Most of our laws are kind of focused, employment laws are kind of focused on one particular topic, but this one, as you'll see, covers many different topics. And so it requires a little bit deeper dive to cover all the different aspects. And so we're going to talk a little bit about the statute generally, and then we'll discuss in subsequent lectures the topics of minimum wage, how that's calculated, overtime wages. We'll discuss the exemptions to the FLSA situation, when somebody can be considered salaried and isn't eligible for overtime, for example. Then we'll discuss the statutory protections for child labor. And here we'll talk about the FLSA, but we'll also talk about state laws in a little bit more detail. And then we'll talk briefly about the Equal Pay Act. That is, of course, a statute that we talked about when we were talking about sex discrimination. So we'll revisit that in this presentation. And then we have a separate section on Texas wage statute. So we'll do a little bit of a state law dive. You know, we haven't talked a lot about state law in this course. And so this is one of these times where we do get to spend a little bit more time talking about the interesting aspects of Texas law. So let's begin. So the Fair Labor Standards Act, and one of the things to notice about this law is the word labor in it. Most of the time, when you see the word labor in a law in the United States, it means that it has something to do with unions. But this is an exception because the word labor here is not referring to particularly focusing on union organizations. I mean, it applies to companies that are unionized and it applies to companies that are union free. So either way will work. So this is a little bit of a surprising name for that perspective. And the reason that the name is different is when the law was passed. This was during the Great Depression. And so the term referring to employees as laborers or referring to labor as a generic term for generally people who work was much more common back at that time. So this is just an indication that our language has evolved over time. This was during, obviously, the Great Depression, and so the FLSA was part of the New Deal that President Roosevelt developed, with the intent of getting more folks back to work and getting them to a point where they were earning a living wage. So the Fair Labor Standards Act focuses upon two aspects of the employment relationship: the pay that people work and the hours that people work. And so those are kind of the concepts. It has nothing to do with discrimination. It has nothing to do with labor situations. Although, certainly, as I said before, this would apply in a unionized facility as well. So, this is a pretty good summary of what the FLSA is about. The FLSA sets standards for the minimum age of workers. So, we do have some child labor in play here, too. It sets minimum wages that the workers can earn, and it sets the rate at which they must be paid if they work over a certain amount of time during a work week. In other words, overtime. So that's pretty much the three categories: child labor, minimum wage, overtime. It also has various record keeping requirements, and these can be quite onerous. And so clients need to be aware of kind of what's involved in the record keeping process. Many employers use professional systems. PeopleSoft's one, but there's lots of others that will do this for employers. And it makes sense whether you're a large employer or a small employer to go ahead and buy something off the shelf for this more so than design one yourself, because it will likely raise compliance issues perhaps, and it certainly is going to be more expensive to develop it yourself than to use what's already available. Very small companies may choose not to buy that type of software products, but even there, I would say that it makes sense I'm familiar with a business that has just one employee, and that business still uses, it doesn't use software, it uses a service that will handle the wages and hour issues. And that's probably money well spent because messing up in this area can be very costly, and it can also be quite time consuming to process all those actions on your own. And of course, the expense factor of doing it wrong is very, very significant. This is it's not so significant when you just have a very few number of employees, but oftentimes in larger facilities, you'll have a significant number of employees in the same situation. So if you mess it up for one of them, you probably mess it up for all of them. And that can result in huge, huge payouts. Millions of dollars are not at all unusual in these situations. Again, especially if you have a large number of workers. Yes, the amount that is owed per day or per week may be quite small per worker, but when you multiply that by lots of weeks or lots of days or lots of workers, you can easily get into 6 or 7 or 8 figures pretty darn quickly. The FLSA certainly has more exposure, more financial exposure for employers on a case by case basis, that say than Title VII or the ADA or the ADEA. You can have class action ADA, ADEA, and Title VII cases, but they're relatively rare. FLSA cases are often class actions, and so in many respects, the risks of FLSA cases are significantly higher than the risks in those other areas. They may be less common to see, but when they do happen, they certainly get the attention of the business. So, who administers this? Well, we've talked about the EEOC administering the ADA, the ADEA, and Title VII. We talked about the National Labor Relations Board administering the labor laws or the union related laws. But for the FLSA, we have a different agency, and this is the U.S. Department of Labor Wage and Hour Division, or Wage and Hour Administration, many times is what it's called. So this is going to be the agency that you're going to deal with. The EEOC isn't going to have anything to do with the vast majority of the Fair Labor Standards Act, although we'll talk about one section that's different. And we'll talk about, well, it's not so much different, but it's a little handled a little bit differently, and we'll talk about that in more detail. This agency is much more like the National Labor Relations Board than the EEOC. When employers see something from the Wage and Hour Administration, they sit up and take notice. The EEOC, most of the time, they're not too worried about it because the EEOC doesn't have a lot of power and is not that likely to be aggressive in most cases. It has been aggressive at times, but it's not known for being aggressive. Wage and Hour Administration can terrify you if you're the employer. Doesn't always terrify you. I mean, I'm not saying that every single case it gets, it does a full court press on the employer, but it definitely has that power and it has exercised that power. And so it is a more aggressive agency than the EOC, which is great if you are an employee who feels like the wage that a particular statute that the Wage and Hour Administration administers has been violated, such as the Fair Labor Standards Act. And we'll also discuss the Family Medical Leave Act is another one that this particular agency administers. And so if you are an employee who feels like there's an FLSA violation, you don't have to go to the Wage and Hour Administration. But that certainly seems like a pretty smart strategy too, because when you do, it may well be the case that the Wage and Hour Administration decides that your case is one they want to look into more, and you may be able to get a resolution quicker and with less expense for you. Like most of these statutes, the FLSA does have an anti-retaliation provision, meaning that if an employee complains about a violation in the law, then the employee suffers some type of adverse action as a result of making the complaint, that person is protected, even if the underlying complaint might not have been completely accurate, as long as it was a good faith complaint. So sometimes the retaliation claim in both Title VII type cases and FLSA cases are scarier for the employer than the underlying complaint, whatever the underlying complaint was about. So the FLSA sets a floor for what the minimum wage and the overtime rules need to be. So the federal law is the floor, but states can provide a more generous benefit to employees. And in that case, a more generous benefit is what is going to apply. So the Congress did not preempt state law in this area. Preemption, of course, is the idea that because the federal government is, in most cases, supreme over state governments, if it is an area of the law that the federal government has authority to act in other words, there's something in the Constitution that gives the Congress the ability to legislate in that area. In those cases, the Congress gets to decide: are we the only game in town? Are we the only government entity that can set up the rules in this area? Or can states also set up rules and whatever is the better for employees, is that what applies? What we've seen with Title VII and with the ADA and the ADEA, the Congress said no, states can innovate in this area as well, and whatever's better for the employee is what the level of protection that the employee will enjoy. We see the same thing with the FLSA. If states give more benefits, then the state law is what's going to control. Of course, sometimes states have lower benefits than the FLSA. That's possible. Um, Usually that happens because the state law is really just focused on the very few employment situations in their state that the FLSA does not cover. And those are really few. And so it's designed to be kind of a little bit of protection for folks who would not ordinarily be covered by the FLSA. Another time that some states have less generous protections than the FLSA is when the state law is just really dated. The state has just chosen not to update it because there's really no need to, because the federal law has changed over time. And so the state government has just kind of not been paying attention to this. So it's not really a statute that gets much attention because it's no longer really applicable. In Texas, we don't have additional protections to the FLSA, so our protections pretty much track with the federal protections. We'll see a few situations where that's not true, but as a general proposition, federal law and state law, Texas state law, are going to track. Again, though, you may have clients that are in more than one state, or you may find that your practice extends to other states at some point, or maybe you actually practice in another state. And so don't assume that the other state is like Texas. Many states have very, very significant protections beyond the FLSA. And so you need to be aware of that possibility before you start giving legal advice to clients. The most famous state for additional protections certainly would be California. It has loads and loads and loads of additional protections that are kind of quirky at times, and um, there can be very, very significant fines for very minor violations. So I'm pointing out California, but it is by no means the only state. It's just the most, I guess, famous for this. So we're going to talk about two types of coverage for the FLSA. I'm going to talk about this here in this slide, but we're really never going to talk about it again because the working assumption that you ought to have is the FLSA applies to everybody. It just does. And so if you start thinking to yourself, well, gosh, maybe my client isn't covered by the FLSA, stop yourself and ask your attorney before you proceed any further, because it's very likely the attorney is going to laugh at you at that point and say, of course the client is covered by the FLSA. Everybody's covered by the FLSA. It's very unusual to find a situation where there isn't coverage. We're going to talk, I guess I think the next slide I may also cover a few. We're going to talk about a few exceptions, but certainly the vast majority of time there's going to be coverage. So there's two types of coverage that we think about. One is enterprise coverage. And when I say enterprise coverage, I'm talking about the whole business. So the enterprise is the employer. And if the enterprise is covered by FLSA, then all of the employees are going to be entitled to protection under the FLSA. Now, that doesn't mean that employees won't be exempt, but what I mean is that the FLSA exemptions will need to be examined to see if the employee is covered or is exempt from that particular aspect of coverage. And then we also have individual coverage of the employees. And of course, we have to look at both of these, the individual coverage and the enterprise coverage. So if you just have one, if the enterprise is covered but the individual is not covered, then those particular FLSA protections that the individual is not covered aren't going to apply. Of course, if you have individual coverage but you don't have enterprise coverage, you don't have any coverage at all. So this is an and situation, not an or situation. So the bottom line is the great majority of employers and the great majority of employees in the United States are covered by the FLSA. Use that as your working assumption until you find out otherwise. So let's kind of drill through here and talk about some of those categories. So first of all, it covers both part-time and full-time employees. So let's consider this scenario. Unicorn Enterprises has about 1,000 full-time and part-time employees who manufacture hand tools. The company policy states that part-time employees are not eligible for overtime pay, even if a part-time employee works more than 40 hours during a particular week. Unicorn Enterprises has violated the FLSA because all of its employees, including part-time employees, are covered by the act and are entitled to overtime pay. I've never actually seen an employer of any size have this policy. And certainly an employer with 1,000 employees isn't going to be this naive. But an employer with 5 employees might be this naive, or 10 employees might be this naive. So um, there could be times where somebody thinks that being part time, having some designation of part time, is going to somehow trump that person's eligibility for overtime pay. Not at all the case. Another thing is the FSLA applies to temporary employees. I mean, in some sense, since we are an at will country, everybody's a temporary employee because your employment status can change in a heartbeat uh, for any reason other than an unlawful reason. So it definitely covers a temporary employee. So if I am hired to work for 3 days, but I work more than 40 hours in those 3 days, I am eligible for overtime pay. And I'm also eligible for the minimum wage during that time. This is one that students just miss all the time, and that is about interns. And I think the reason why students miss this question all the time is that our culture misses this question all the time. So many employers, even smart, savvy, ethical employers, do not comply with the law in this area. I don't understand it. It's not a hard law to comply with. It's not even an expensive law to comply with. But people just don't choose not to. And they are doing it at their own peril for sure. Generally speaking, unpaid internships are unlawful. It's not that it is impossible to structure an internship that is unpaid, that is lawful. It can be done, but almost nobody ever does it. The general rule is that if the intern is providing services to the employer that are beneficial to the employer, in that situation, you got to pay the employee. You got to pay the intern. The times that you don't have to pay the intern would be if the intern is just job shadowing somebody. He or she is following a paid employee around and just seeing what that paid employee does. In that situation, you don't have to pay the intern. But pretty much every other situation, the intern needs to be paid. Let's say that I'm an intern and I'm job shadowing 80% of the time, but I do work as the receptionist during, say, the lunch hour or when the usual receptionist is entitled to a break. During that time that I am actually performing services for the employer, I need to be paid. And it's even possible I need to be paid when I'm job shadowing if I'm actually doing the other work. So it's a best practice if you are going to have unpaid interns to just really not have them do anything of economic value. Don't make coffee. Don't sharpen pencils. Don't run the photocopy machine. Excuse me. Go ahead and have that person be just a pure fly on the wall in whatever's happening in that particular day. Now, if you do want to provide an internship possibility, but you want that person to perform work that is of economic value, then I suggest, excuse me, that you pay the person a minimum wage. That's probably dramatically less than the value of the work that they're going to actually perform for you. But go ahead and pay them that with the understanding that for the most part, this is an unpaid job, but so that we can fully comply with the law, we're going to give you kind of this symbolic pay. In that situation, the employee would obviously be eligible for overtime, so you have to make sure that you're not keeping your interns beyond the normal 40-hour type position. So, no, you cannot have somebody work on a trial period for you to see if they're going to work out and then decide whether you're going to hire them or not at the end. That is not lawful. That is not a good practice. That is a practice that has all kinds of FLSA exposure. Plus, it's very unfair to the worker. Most people do not have the opportunity to work without pay. I have a friend of a friend, and this, or actually a son of a friend who graduated from college and who worked for about 4 to 6 months as a quote unquote intern. He had to work 40 hours a week, the son, and he had to commute to downtown Dallas. He had to, so he had to drive his car. He went down the Dallas North Tollway. He had to find parking for his car. He had to have all the right clothes, which were not inexpensive for him to purchase. And so for those 4 to 6 months, he was costing him a significant amount of money. Now, my friend allowed his adult son to live with them and helped the son pay for the bills so that the son was actually able to afford this extremely long internship. At the end of the internship, the young man got a full-time job and ended up, probably earning six figures very quickly because it was a lucrative area of employment. And so he was able to make the transition from, a 22-year-old who wasn't earning any money to, probably somebody earning, if not 100,000, close to 100,000 very, very quickly. So it was a good investment for him. But there are unfortunately lots of people who couldn't go 4 to 6 months with those types of expenses and no paycheck. And so that's one of the really deeply unfair things about these types of interns. It allows people who have a family network um, to partake in them, and therefore to allow the person to um, ultimately get a high income by you having an unpaid internship. Much better for the employer to not jump the pay up to 100,000 as soon as the internship is over, but to pay minimum wage or something similar during those 4 to 6 months. And if you can't afford to do that, then just reduce the pay once the job switches from the internship to the normal position. I think one of the reasons why employers don't pay their interns isn't so much that they begrudge them the money, but it's the notion that this person isn't quite an employee yet. And so they're kind of entitled to end it whenever they want to, that there's a set date and they can go ahead and say, okay, your internship's done. Thank you so much for your service. Go about your business. We won't be continuing this. And so it's a way to kind of set up a break in the relationship that's a little bit cleaner than having somebody as your employee and telling them we don't want you around here anymore. That's kind of a tough conversation to have. And so I think that that's probably the big difference. So one way to approach that is to still use the word intern and say this is just a 4 to 6 month gig. We're not saying it can't be extended longer. It might be, but there's also a really good chance it won't be extended. And during this time, we'll be paying you the minimum wage. And so that will be the deal. And at the end of it, you know, the answer may be bye bye, or the answer might be here's a position. That can be a way for employers that are a little bit skittish about just treating these individuals as normal employees, but they do need to be paid. So let's talk about nonprofit companies. They are also covered by the FLSA. But nonprofit companies, of course, can use volunteer labor, and unlike for-profit companies. I mean, nobody volunteers at Exxon, right? Nobody volunteers at Kohl's, the department store. That doesn't make any sense. You don't volunteer for profit businesses, but you do potentially volunteer for nonprofit entities. So let's consider this scenario. So Bob is an environmental enthusiast and he volunteers to work as an intern at Green Dragon International, a nonprofit organization dedicated to environmental issues. Green Dragon hires Bob without any pay. Green Dragon, under these circumstances, did not violate the FLSA because unpaid internships at nonprofits are generally permissible. Now, what you can't do, though, what Green Dragon can't do is hire Bob and pay Bob, say $10 an hour, and then also let Bob volunteer for Green Dragon at other hours. So saying, okay, Bob, you work 40 hours a week for us at $10 an hour, so we're going to pay you, $400 a week. But we'd also like for you to work 10 extra hours on Saturday, and that will be for free. That won't work. So you can have Bob be a complete volunteer for Green Dragon for the 50 hours, or you can pay Bob for the 50 hours, for 40 of them at normal pay, the additional 10 at time and a half. We'll talk more about how overtime is calculated. But you can't have this hybrid person who's, an employee sometime and a volunteer sometime. You can't have that even at a nonprofit. Federal, state, and local employees are also covered by the FLSA. So you can see here, not too many categories are left off. And the law even covers domestic service workers. Now, there are some exceptions, though, here. So let's look at what the exception is for domestic service. When we say domestic service, we're talking about maids, uh, 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 janitors, butlers, I guess, nannies, lawn service folks, people along those lines. So the FLSA does not entitle domestic workers who live in the employer's house overtime pay. Because the idea here is that when you're living in the house, when you're actually working and when you're not working can be a difficult thing to determine. In some sense, you might be on call a lot of the time, even though you don't have any active responsibilities. For example, let's say you're a nanny and you're responsible for taking care of the baby. Well, I mean, the baby's asleep a lot of the time. But if the baby wakes up, you need to be there changing the diaper or feeding the baby or whatever. And you still need to be present in the house when the baby's asleep, for the baby's safety. But since you live there, you can be, hanging out, watching Netflix or, filing your nails or whatever you want to do. And so when you're actually on duty or not would be a very complicated thing to look at. And so therefore, under those circumstances, there is no overtime pay that people under those circumstances are eligible for, at least under the FLSA. Now, of course, an individual employer can set up uh, more generous benefits than the FLSA provides. So an employer can say, look, I will pay you overtime once you work beyond these hours. That is certainly something to be considered. Okay, so let's look at the two requirements that we're going to need to establish for FLSA eligibility. The first thing is that we need an employer employee relationship. Okay, let's think back. I know this was like, it feels like 4 years ago at this point, but let's think back to one of our very first modules where we talked about, is a person an employee or are they an independent contractor? And you may have almost forgotten about that analysis because it hasn't really been something we've talked a lot about, but here it comes up again. I mean, it really was in the background of all of our other lectures because, in the vast majority of cases, if a person is an independent contractor, the legal protections we've talked about haven't applied. If you're an independent contractor, Title VII doesn't apply to you, the ADEA doesn't apply to you, the ADA doesn't apply to you, the NLRA doesn't apply to you, and guess what? The FLSA doesn't apply to you. Almost all of our laws do not apply to almost all of our labor and employment laws do not apply to an independent contractor. So we're going to yet again kind of refresh ourselves on this topic because even though it doesn't apply in those other circumstances, it's pretty rare that you see cases that talk about that type of issue. It's just not something that usually becomes an issue in those situations. But under the FLSA, it sometimes can be an issue, or it's more likely to be an issue. The other thing that we look at, and again, this is an and situation, so you have to satisfy both of these, is that the employer's activity must meet the in commerce requirement. But you know what? This is just a constitutional requirement. You may recall the Commerce Clause in the Constitution that Congress can only regulate, or Congress can regulate commerce among the several states. Well, that's the uh, constitutional authority for the Congress being able to pass the FLSA. So if an employer is not engaged in interstate commerce, the Congress has no authority legally to tell that particular employer how to run its business. So that's the reason for this requirement. The Commerce Clause. Um, but you know what? This is almost never an actual, the second requirement here is almost never an actual limitation on the applicability of the FLSA to employers because virtually every business is going to be engaged in interstate commerce. It's difficult to think of any business of any size at all that isn't involved in interstate commerce. In fact, I would submit to you, even businesses with one employee almost inevitably are. So, this one, yes, it's technically a requirement in the statute. Um, and I'm not going to say it's impossible to think of a pattern where this would apply, but again, if you start thinking to yourself, oh, I think my client is maybe not engaged in interstate commerce, before you go any farther, talk to the attorney because 99 times out of 100, the attorney will say, uh, no, this is an interstate commerce situation. So the one that we're really going to focus on for the next couple of slides is this issue of is there an employer-employee relationship? And again, this is going to be a refresher. It's stuff we've talked about before, but it was quite a while ago. So let's do a bit of a refresher here. Before we do the refresher, though, let's look at three areas that the FLSA applicability has been focused on. So, who is a covered employee? Okay, again, are we looking at is this person an independent contractor or an employee? How are we going to determine the hours actually worked by this particular employee? Now, you may think to yourself, well, that doesn't sound like it would be hard. Just see when they clocked in and when they clocked out, or see when they were working. Well, many times and for many positions, it is very obvious what the hours worked are. But for other positions, we'll see that it can be a very, very murky situation. And then we're also going to see that there can be challenges with calculating the rate of pay when a particular employee works beyond the 40 hours a week. How do you decide what time and a half means? Again, for most employees, it's very straightforward, very easy, but there are other situations where it can be very complicated. And both of these areas are situations where employers can be acting pretty conscientiously and still mess up and potentially have exposure for lots and lots of money. So it's really, really important that the employers be up to date with how to make these calculations. Number one, so they comply with the law. And number two, so that they don't have some kind of huge penalty or huge payout to employees that was unexpected and unbudgeted for. Okay, so let's look at this case. This case is from 1948, and our understanding of the Interstate Commerce Clause was still evolving. So back in 48, they would have had a more narrow understanding of the scope and breadth of the Commerce Clause than we do today. This one, the question presented at this time is, does the FLSA apply to a business that for most part sells goods and services in intrastate commerce? In other words, within the borders of a state? And the answer is yes. So even if most of the business is just within a state, it is still covered by the Commerce Clause, and therefore the FLSA applies. Now you'll see in the holding there's this whole discussion about the corner butcher shop or the barber shop, and maybe they're not involved in interstate commerce. And in 1948, perhaps the thought was they weren't engaged in interstate commerce. I would tell you today that some of that parts of the cow that have been butchered are probably from a different state, and the heads that are coming in to be barbered sometimes may be from a different state. And the equipment that you use may be from a different state. And so even nowadays, the corner butcher store and the barber shop are probably engaged in interstate commerce. So don't overread this case and assume that these exceptions that they talk about are somehow still actionable. Certainly, Coast Van Lines is engaged in interstate commerce, And again, almost all businesses of any size are going to be covered. You don't need to know the name of this case. This is just an example to show you, or hopefully show to you, that it's a very, very broad covering of the interstate commerce protect or of the FLSA. But here's, we talked about how it's got to have interstate commerce. This is something don't really pay attention to. But this one, whether there is an employee employer relationship, that still has relevance. That is actually an area where you might find the FLSA really doesn't apply to a particular employee. So, just a refresher, the FLSA does not apply to independent contractors or to principal agency relationships. In other words, non employment relationships. And again, it applies to both union and non union workplaces. So if if the worker is not covered by the FLSA, then the worker is not covered by overtime or minimum wage protection. So this is an important analysis to make. Now you don't want to mess this up. This is, we talked before about how, well, it's hard to know whether somebody's, in many cases, whether somebody's an independent contractor or an employee. Most employers' position is to err on the side of designating somebody as an employee because the legal risks of screwing it up are just too awful to contemplate. Millions and millions of dollars by misdesignation. And so most employers will say, you know what? Um, if you think about it as a continuum, here's somebody who's clearly an employee over here, and here's somebody who's clearly an independent contractor over here. And then in this area, we've got gray area. Well, most employers are going to say, you know what, if we're in the gray area, we're going to treat the person as if he is an employee. It's only when we're really not in the gray area where we're going to consider the person an independent contractor. That is what your attorney is likely to recommend for clients. So there are some clients out there that take a more aggressive position. They want to designate more people as independent contractors. Um, that works really well until the Wage and Hour Administration comes out and decides to do an audit, or decides to become more aggressive. And then can look back 3 years. So you don't necessarily have a lot of warning. It is a high risk and not so high reward situation. So it's not a smart plan, but you will have clients who do that. Usually, they are not seeking the advice of counsel before they do that. They only are seeking the advice of counsel when they feel like they've been caught by the Wage and Hour Administration. And so that can certainly present challenges, but it's certainly going into it not a smart strategy. If a person is in that gray area, go ahead and treat them as an employee, or restructure the job so it leaves the gray area and becomes more of an independent contractor situation. This is another example case that we're going to look at. You don't need to know it. As you can see, it's just from a district court, so just from a trial court, not something to be overly focused on in terms of an important precedent, but I think it's a good example. So the issue this case is looking at is what constitutes a reasonable basis under the IRS code to classify a worker as an independent contractor. So we're looking at the IRS rule, which is certainly relevant to how the Wage and Hour Administration might consider some of these issues. Okay, so the IRS contended that this particular nursing business, it was called Critical Care Registered Nursing, uh, it was a business that employed, or I guess I shouldn't say employed, it had nurses who worked for hospitals, and it was kind of like a staffing business. Anyway, the IRS was saying that this business should have treated its nurses as if they were as employees and therefore collect various employment taxes. But the evidence showed that the company did not dictate that the hours that the nurses were to work, did not provide uniforms for the nurses, did not provide transportation for the nurses, and did not provide any kind of fringe benefits to the nurses. So the nurses were free to choose when, where, and how often they would work. For these reasons, the company said that the nurses were independent contractors and therefore not employees. And in this case, the court ruled with the employer, ruled with critical care, and said, nope, these individuals were not employees, and therefore uh, the company was entitled to not withhold employment taxes or pay the relevant employment taxes as an employer. I'm offering this just as an example. I will not test you directly on it. You don't need to know the name of the case. I just wanted you to get an example of how these work out. And most of the time, the employer loses. So, this example of an employer winning, and I think it was right that the employer won in this case, don't get me wrong, but more employers end up being sad at the end of the conclusion of these cases than are happy. So, keep that in mind. Okay, so we've already talked about how the FLSA does apply to not for profit employers and also religious entities. So, churches, synagogues, mosques, if they have employees, they will need to follow these rules. Obviously, it also applies to traditional commercial businesses, but you probably already assumed that. Now, again, not for profits and religious entities, which are a category of not for profits, are fully entitled to have lots of non employee volunteers. Um, but if they have people like secretary, and they can even have secretary volunteers. There are lots of, especially smaller non for profits or smaller religious congregations that don't have any employees at all, which is perfectly fine. But oftentimes, the idea eventually is, well, we want to have somebody who, we can really count on being there every day, who really has the particular skills that we want. A volunteer typist may not be that accurate, and it's kind of hard to fuss at them if they keep on sending out letters with typos. So oftentimes, those even religious or nonprofit businesses will say, you know what, we really need somebody who we can put pretty significant expectations on, and therefore we're going to want to uh, have them as an employee. Let's consider the family business exception. So, if the only employees of a particular business are the owner and the owner's immediate family, the FLSA does not apply. So, these are family run businesses like a small restaurant. Mom and dad own the restaurant, they're in the back cooking. Junior and Sally are the hostess and the busser and the waiter and the waitress of the business. Under those circumstances, those employees do not have to earn minimum wage and they are not eligible for overtime pay. So the restaurant, it could be a dry cleaners, it could be a lawn care business, it could be any business really. Once the business starts hiring people who are not family members, then the family business exception goes poof. So it is a limited exception. You can see typically this is going to be for very small businesses. So under the FLSA, we're looking at the economic reality test. Um, as we talked about before, if the worker is in fact an independent contractor under the economic reality test, then the FLSA is not going to apply. So this is how you want to look at it. And so here are some of the factors. This is just a rehash of what we talked about before. Let's just go through these really quickly. The extent to which the services rendered are an integral part of the principal's business. If they are an integral part, then it's more likely the person is an employee. The permanency of the relationship. The more permanent, the more like an employee relationship. So the longer it's expected to last, the longer that it does last points to employment. The amount of the alleged contractor's investment in facilities and equipment. If I'm a welder and I bring my own equipment, maybe it costs me a couple $1,000. I'm looking more like an independent contractor. If I come to work and my equipment is provided, I'm looking more like an employee. The nature and degree of control by the principal. If my boss is telling me how I should do the work, not just what the work that needs to be accomplished is, then I am looking more like an employee. So if I am a carpenter and I am told put the cabinets in, but I'm not told how I ought to put the cabinets in, I'm looking more like an independent contractor. The alleged contractor's opportunities for profit or loss. So if I'm a carpenter and I get to source the cabinets that I'm buying, the raw materials, and I'm just giving a final price for the item to the end user. Maybe I'm going to make a profit off of that deal. Maybe I'm going to make a loss off of that deal. But if I'm strictly paid my hourly rate for that time, there's no opportunity for a loss if I'm not providing, my own equipment and my own supplies. The more that I have the opportunity for profit and loss, the more likely I am an independent contractor. The amount of initiative, judgment, or foresight in a competition with others required for success moves that person to more an independent contractor. Again, if I'm a carpenter and I'm going out there and figuring out how to price things because I'm looking at what my competition does. Oh, Bob, my competitor, priced that at X dollars. For those cabinets. So next time I'm going to keep that information in my head and I'm going to do slightly lower than X, or maybe I'm going to use slightly higher quality supplies and charge a little bit more, whatever my particular business model might be. All of those things are me thinking like an independent business owner, not so much like an employee. And again, the degree of independent business organization and operation. Am I incorporated? Do I have an LLC? Do I have my own employees? Do I have my own office space that I'm actually providing for myself? All of those things, again, would point to independent contractor status. So let's consider the Patel case. This isn't one that's important for you to know, but I think it is useful. I think it's important from this perspective to notice the year of this decision. If this decision had come down during other years, I think the decision could have been different. We as a country typically kind of vary in how concerned we are about workers who lack the correct documentation to work in our country. Sometimes in our history, we've been very concerned about those individuals working, and so we've been less inclined to provide them with other statutory protections. At other times, we've been more concerned about the quality of their working lives, even though they shouldn't have been working according to the law, and so therefore we have extended them protections. In 1988, we were more concerned, I think, about the human aspects of people working, and so at least in this case, in the 11th Circuit, Mr. Patel was entitled to overtime pay even though he was ineligible to work. So in this situation, Mr. Patel was an undocumented worker. He went to work for Quality in South, um, and of course, Quality in South hired him to do this work. Now, back then, this is before um, the I-9 requirement existed. So, Quality in South was not required to confirm that Mr. Patel was eligible for employment at this time. Anyway, so I don't know if Quality in South knew Mr. Patel was not eligible to work in the United States or whether it didn't know. It's not actually relevant to this analysis. So, anyway, he performed kind of handyman and maintenance tasks for several years for Quality in South. And he ultimately sued his employer, saying that he was not paid minimum wage for that time. And even though he worked a lot of overtime, he was not paid time and a half for that time. And so he sought a not trivial amount of money. Again, this is back in the 1980s. But he also sought liquidated damages, which would double this amount, and attorney's fees. So probably Quality in South was looking at uh, close to $200,000 of exposure from one employee who they had hired because probably they could pay him very little money. So they were looking to save money by hiring Mr. Patel, and now they face the possibility of paying a significant amount of money. Um, but in fact, Quality in South uh, potentially could be having coverage. I don't know. It was remanded, so we don't know exactly what happened to the case when it was sent back to the trial court. But the Court of Appeals in this case focused on the fact that Congress did not exclude undocumented workers from the coverage of the FLSA. So the 11th Circuit, which isn't our circuit, we're the Fifth Circuit, but um, it is generally a fairly conservative circuit. Um, it held that undocumented workers were protected by the FLSA. So we're entitled to minimum wage pay and we're entitled to overtime pay. So you don't need to know the name of this case, but you do need to know its holding. Okay, this is a weird one. I don't know if you know anything about the Tony and Susan Alamo Foundation. It's been investigated many, many times by the federal government. So I'm not interested in you knowing about the entity here. We're more focused on the Tony and Susan Alamo Foundation had many creative ways of taking advantage of people, to put it mildly. Anyway, this is one of their schemes that was, look, I mean, into its credit, was rather creative. So let's look at it a little bit. So, do the commercial activities of a nonprofit business, because that is what this business was, technically. So, do the commercial activities of a nonprofit business that compensates workers with non cash benefits cause the business to be subject to the FLSA? And fortunately for those poor workers, the answer was yes. So, let's look at the facts of this case. So, this foundation derived income from running various normal commercial businesses, just normal businesses, but it would in theory, be this nonprofit running these businesses. And so these commercial businesses that it ran staffed them with people they called associates. They weren't employees, they were associates. Now, before we go on, and I'll tell you the rest of the story, it is fairly common in certain industries for people to be called associates. For example, in a law firm, attorneys who are not yet partners but are on partnership track are called associates. Legally, they're employees, but from a terminology perspective, they're called associates. If you go to work for many retailers, they will call their employees associates. Certainly at J.C. Penney and at Walmart, and I'm guessing many, many other employment situations, are called associates. Legally, they're employees, but the term is associates. So the use of the term associates is not unlawful. It just uh, means employees in this context. But in this case, for this foundation, it didn't mean employees. These associates were kind of the clients of this foundation. They were individuals who had come to this foundation seeking help because they were in a crisis situation. Many of them had substance abuse issues or they had a criminal background. Maybe they had been released from prison and they kind of couldn't figure out how to maneuver in the world at large. And so they were, being helped, or at least that was the concept of this foundation, that they were going to be helped to be rehabilitated. And while they were being rehabilitated, they were going to help in these associated businesses. Well, as these individuals were working, they received no salary, no money whatsoever. Now, they lived in the facility, so they were fed, they were clothed, they did have a roof over their head, they received other benefits. And so, what this foundation said is, we're taking care of these people, and they don't need money. We're rehabilitating them. They're our clients, they're not our employees. Well, the Department of Labor said, these people are employees. Yes, you can certainly help them with their substance abuse problems and their adjustment to non incarceration, but while you're doing it, go ahead and pay them. Pay them minimum wage, pay them overtime, and follow the normal record keeping requirements of the FLSA. And in fact, the court said that the operation, Tony and Susan Alamo Foundation, was an enterprise and the workers are employees. So back here, you may recall we talked about the two requirements. A little refresher here, yes. Or actually, let me go back even farther. Yeah, the enterprise coverage and the individual coverage. In both cases, these individuals were in fact covered. The Supreme Court held that the Foundation's commercial activities with a common business purpose were not beyond the reach of the FLSA. Now, I'm not going to quiz you on this case or its holding, but I'm offering it to you just to show you that quote unquote clever employers who try to obfuscate or avoid the FLSA are usually not very successful. The FLSA applies to virtually everyone. So let's look at the remedies, in other words, the rewards that successful plaintiffs will earn in an FLSA case. So we first of all have lost wages. So this is very similar to what we see with Title VII, the ADA, the ADEA. Um, uh, in some cases, the FLSA employee has been dismissed, and so it could be 100% of the wages that the person might have been eligible to receive during that period of time. But probably more commonly, we're looking at somebody who is just underpaid for a period of time. It could be that they were paid sub minimum wage, so they would be entitled to, let's say they were paid, we'll say $5 an hour, and they should have been paid. And I'm not actually sure what the minimum wage is now. For just clarity's sake, we're going to say it's $9 an hour. I know it's not that, but just to make things easier mathematically. So for each one of those hours, the differential would be $4 an hour. And so let's say this person in a particular year worked 2,000 hours, then they would be entitled to a total of $8,000 per year in pay because of underpayment of wages. And that might be back as many as 3 years. So we could multiply by 3 and see we're looking at 24K in this particular example. And as I say, very commonly there's more than one employee in this situation. So let's say there's 10 employees, then you'd have $240,000. It could also be that the actual, again, let's assume that the minimum wage is $9, which isn't true, but let's just assume it. They could be paying that correctly, but they didn't pay overtime correctly. And this is probably a more common scenario. And so let's say that the person worked overtime 10 hours a week every week, or on average at least 10 hours a week. And they were just paid their straight time. So they were paid $9. They were actually paid for their overtime, but they were paid $9, not 1.5 times $9, which of course would be $13.50. So they would be entitled to $4.50 times the 10 hours. Well, again, we're saying 52 weeks times the 52 weeks times potentially 3 years. And so this would be about $45 times 50. Well, anyway, I don't know the numbers. You can crunch the numbers and see. It's not a trivial sum. And again, if you're making this error for one worker, you're probably making this error for lots of workers. And so you might end up having to multiply this by 50. And so you get into some significant money at this point. So that's the idea behind lost wages. Then you have attorney's fees. Attorney's fees are oftentimes, especially if you just have a small number of workers, the attorney's fees can be greater than the amount of lost wages. We see this pretty routinely in Title VII cases, and we can absolutely see this in an FLSA case, especially when the number of workers are small. You can have court costs as well. These costs are um, probably in the $20,000 to $30,000 range. Deposition costs, jury fees, things along those lines. So court costs are usually not huge, but they're not, nothing either. And then we have liquidated damages. Again, we saw this in the Age Discrimination and Employment Act. Instead of having punitive damages, you just double the lost wages. Now, you don't double the attorney's fees, you don't double the court costs. And this is available when there's a finding of willfulness. And willfulness is pretty easy to find under the FLSA. You can't say, well, we weren't willful because we just never really kind of figured out the law. No, that's not going to work. If you're willfully ignorant of the law, you're still willful. There can be areas of the law where, gosh, there were two reasonable interpretations and we took one, but it was reasonable, and the court says no, we're going to go with the other interpretation. In that situation, the court may not find willfulness, but I would say at least half of the time, willfulness is found in FLSA cases, so double damages are pretty common. So instead of it being 24,000, certainly in this case, we would expect to double that amount to 48,000. Somebody who literally pays less than minimum wage, that's got to be willful. We can see that we have a longer statutory period than we saw with Title VII and the ADEA and the ADA. Instead of 300 days to file your charge of discrimination, you have 2 years. And if it's a willful violation, that deadline is extended to 3 years. So, pretty long period of time to look back for these purposes. And of course, one of the challenges here is that you might be living in an environment right now, whenever today is, where the Wage and Hour Administration isn't being very aggressive in your area. And so you might say, okay, I'm safe. But 3 years from now, it may well be a different environment. And they may look back, and that time you thought you were safe, you really weren't safe. So you don't want to take undue risks in this area. So, we've been talking about kind of how broad this law is and all the things that it applies to, but there are also important areas that aren't covered by federal law. And these are oftentimes surprising. Hopefully, in this course, you've seen that there are times where uh, it's surprising how great the scope of the law is in employment law. And then there are other times where you've probably been surprised. And you're like, gosh, I thought for sure there was a law about that. There really isn't. Well, this is one of these areas where you're probably going to be surprised to see that there isn't much regulation in this area. Many employers, or let me put it this way, many managers think there is regulation. They think that the reason why their place of employment, for example, has breaks for workers is because there's got to be some law somewhere about that, right? But in most cases, outside of states that have protections, there aren't laws about these types of topics. Now, when I say there aren't laws, what I don't mean for you to interpret this to mean that they aren't good practices. They are good practices to give employees breaks in these areas, but they are not statutorily required in most cases in many states, and certainly not in Texas. So let's go through what we are not seeing as requirements. So there's no law that says that an employer has to provide vacation time or holiday pay or severance pay or sick pay. None of those are statutorily required. There's no requirement that an employer provide meal periods or rest periods such as breaks or hot days off from work or vacation days, paid or unpaid. There's no requirement that an employer give premium pay for weekend work or shift work in the evening or holiday pay. If you work on Christmas Day or you work on New Year's Day, there's no law that says you have to be paid some kind of premium. There's no requirement that an employee gets a particular notice of discharge. Now, a pink slip can be required in some states. That's where that expression comes from. Some states require that they be pink, or at least sometimes they've been pink. And those slips were given to folks so to facilitate them in filing for unemployment benefits. Um, there's usually not a requirement that a person give a reason for discharge. And there is not a requirement that there be some kind of immediate payment of final wages. There are some states that require this, California, for example, but there's several others. The way that it plays out for employers in that situation, though, it is kind of an example about how employers will uh, work within a statute, comply with it, maybe comply with the letter of the statute, but not the spirit. So let's say that you've caught an employee stealing. I mean, you just caught them 15 minutes ago. You had no idea they were stealing until 15 minutes ago, and now you're 100% sure they're stealing. You don't want them to work for you anymore, obviously. And you're right not to want them to work for you anymore. In states that require immediate payment of final wages, that can be difficult to handle because, especially if you're in a larger company, the payroll processing system is really separate from your other systems, and it's done on a weekly or biweekly basis or something like that. And so it's not an easy thing to jump in there and figure out how many hours this person works and figure out what the withholding is going to be and make sure all the withholding happens and make sure all of the I's are dotted and T's are crossed. It's an involved process, and it's really not designed to be interrupted easily. So what large employers do in that situation is they don't fire the employee then. I mean, they know they're going to fire the employee, but they say, go home. We'll be in contact with you about your employment status. And then they contact wherever their payroll handling department is and they say, look, I'm going to need an expedited check. And so then that process and the payroll request is processed in a way to make sure it's fully compliant with all state and federal laws. And then that check is overnighted or to the unit. And it may take 2 or 3 days for all of those I's to be dotted and T's to be crossed. And so now the unit has the final pay for this person who they always do they were going to fire. Now they call up the person and say, okay, we're ready to meet with you. Come back in. If the employee actually does come in, and many times they don't because they know they're being fired, um, then they come in, they say, okay, you're being fired. Here's your immediate payment of final wages. Um, so under those circumstances, you can see that yes, the statute was complied with, but in reality, instead of paying this person quicker than they otherwise would have, what they do is they just delay the termination date. So it's a little bit of a sleight of hand that sometimes you'll see in these states. Now, in states that don't have immediate payment at the time of dismissal, um, employers typically don't do this. In Texas, is not an immediate payment at the time of dismissal. Typically, you have 6 days. We'll talk more about that later on in a subsequent lecture. Um, Federal law also does not limit the number of hours that a person can work in a day or the number of days a week a person can work, as long as that worker is at least 16 years old. Now, workers who are 14 and 15 can work under the FLSA, and there are limitations upon the hours. Now, of course, state law oftentimes does limit the number of hours a person can work, or at least provides that they are eligible for daily overtime if they work over a certain number of hours. State law can also limit the number of days a person can work in a row. And they can also, put additional limitations on 16 and 17-year-olds. So you do want to make sure you're checking state law in this area. And then, of course, federal law does not require pay raises or fringe benefits really of any type. So these areas, federal law isn't going to apply with. Now, we will see for the 14 and 15-year-olds, there are some limitations here. But if we exempt those and just look at the 16 plus population, federal law is not going to be relevant in this area. And for the most part, Texas state law is not going to be relevant in this area, although we do have some discharge protections in terms of when pay is going to be released. We'll talk about those later on in subsequent lectures. Okay, so we're going to look at the FLSA and state law. So as I said before, in many states, there's lots and lots of regulations in this. There are states, again, like California, where the state law is actually a much bigger deal than the FLSA. You will also find a not small number of places that have local ordinances, particular cities that have a super minimum wages. You may be at $15 an hour. There seems to be a popular point for that. And so a state, you may have the federal minimum wage at this level. You may have the state minimum wage at this level, and then you may have the local minimum wage at this level. Now, can sometimes be issues about whether the local ordinance is actually legally permitted under state law, because all localities, county, or city ordinances are creatures of state law, and they can only exist to the extent that state law allows those ordinances to exist. So sometimes there's a disagreement between the state legislature and the local government officials as to whether there's the authority for this particular ordinance. So not all those ordinances end up being enforceable, but many of them do. And so if you're the employer, you kind of have to decide whether you're going to comply with that ordinance or not. Most of the time, it's probably a good idea to do so. Let's consider this situation. So Bob's a cashier located in Wyoming, and he's paid the minimum wage set by the state law in Wyoming. In Wyoming, the minimum wage is actually less than the federal minimum wage. Almost certainly, eager beaver discount is involved in interstate commerce, so the enterprise is covered. Under these circumstances, Eager Beaver has violated the FLSA because the federal minimum wage is going to supersede the state minimum wage, again, as long as there's enterprise coverage, which almost certainly there would be. Because some of the things that Eager Beaver Discount are selling are surely from other states, right? Texas does have an FLSA equivalent statute, but since it mirrors the federal law, they're really not going to be, this isn't going to be an issue, at least not nowadays in Texas. But again, other states that can be. So, other states, again, not so much Texas, but other states may well have rules about all those topics that we talked about before. So at this point, we have covered our first section of our FLSA section. We've done the overview of FLSA and we've discussed the scope and coverage of the statute. In subsequent lectures, we'll cover minimum wage, overtime pay, the various exemptions to the FLSA, child labor rules under federal law, and very briefly the Equal Pay Act. Finally, we'll talk about Texas wage statutes. At this point, I'm going to go ahead and end the presentation. I hope that this information has been helpful for you. Again, as always, if you have any questions about the material, please feel free to pop into my office hours. I'd be delighted to talk with you about more detail about these topics. I hope that you have a wonderful day, and I thank you for your attention. Bye-bye.